This is civil practice, and I'm doing a screenshot video. It's the first video for weeks 6 to 7, and it's posting for venue and statute of limitations / notice of claim. I believe we've already done venue. On an earlier occasion, it happened to be in this posting as well, but I do want to take the opportunity to point out that since the material in the textual handout had been prepared, there was a change in the law in the state of New York, so that we want to go back, if we haven't done so, to paragraph 3 on page 13 of the textual outline. For New York State Supreme Court, venue can be placed, if you will, in either the county of the plaintiff's residence, the county of the defendant's residence, or the county in New York State in which the claim occurred. So the rule used to be that it had to be based on residence only, and now we have possibly another choice. When I say possibly, if plaintiff and defendant live in Erie County and we have a vehicular accident in Erie County, then Erie County is the only place of venue. But let's say plaintiff is a resident of Cattaraugus County, defendant's a resident of Niagara County, and the vehicular accident occurred in Erie County, we'd have 3 different choices of venue if we were the plaintiff. I want to get into the next topic then, which is statute of limitations and notices of claim. And I point out that these 2 topics are covered in pages 15 and 16 of the textual outline. And I would certainly want you to be looking at the different time periods that I have set forth in 15 and 16. But let's just begin with a basic concept. In a civil lawsuit anywhere in the United States, there's something known as a statute of limitations. And that's the period of time that a person or entity has in which to bring the lawsuit. And we call that the statute of limitation period. And I give you an illustration here. It's very basic. But let's assume, again, that someone comes into our hypothetical law firm and tell us that they were injured in a vehicular accident on August 15, 2020, and we have a personal injury claim. You'll see that the statute of limitation period is 3 years, which means that we would have no later than August 15, 2023 to commence the case. And as I point out, we don't have to wait and flirt with not complying with the statute. Even if we were retained today, because when I did this, it was last fall, I believe. But even if we were retained today, we'd have lots of time in which to bring the case. But certainly we want to bring the case reasonably soon when it's we feel it's the right time, but we've got to just be mindful of the statute of limitations period. I also note that some of the statute of limitations are very short. So a claim against a governmental unit in New York State for non-monetary relief, which is known as an Article 78 proceeding. Let's assume in our hypothetical firm we're representing a developer and a town has turned down our client's request for a use permit to put up some kind of building in which to run a business. We want to challenge that decision. The challenge would be suing the governmental unit, in that case the town, for non-monetary relief, and that's known as an Article 78 proceeding. The reason it's known as an Article 78 proceeding is that the number of the article in the New York CPLR that sets forth the rules for bringing that case is, of all numbers, Article 78. So the general statute of limitations, as I point out to you and if you look at page 16 in the textual outline, is 4 months. And obviously 4 months can go by very quickly. And one of the points I want to make on this statute of limitations is when someone comes into our hypothetical firm, that's one of the first things I want to figure out. Because they may have come to us, let's take that 4-month period. They may have been lawyer shopping. They may have been just thinking about whether they want to see a lawyer. And we may be near the end of the 4-month period. I want to know that when I'm speaking with a client for the first time, rather than say to the client, yeah, well, why don't you send us that stuff you've got and we'll take a closer look at it. And between the day I say that and the day I get the extra stuff, the statute of limitations has expired. And I think I may very well have, if I did something like that, or we did that in our hypothetical firm, I think we may have committed negligence, or as they like to say, if an attorney does it, legal malpractice. Indeed, sometimes the period is shorter in these Article 78 proceedings. And you'll see that to challenge a decision of a zoning board of appeals, you only have 30 days. So one always has to be careful about the statute of limitations. I suspect what I should also do right now is point out, because I don't think I have explicitly, when we're facing a statute of limitations, which we always are if we're going to be representing a party who's going to be bringing or possibly bringing a lawsuit, we have to commence the case, commence the action, or commence the proceeding before the deadline expires. And what we're going to learn a little bit later on is we commence the case in New York State Supreme Court, or for that matter in federal court, by filing our commencement papers, which in New York State Supreme Court would be a summons, or if it's a proceeding or a special proceeding, a notice of petition. Typically, a complaint goes with a summons. Typically, a petition goes with a notice of petition. But we've got to file those documents before the deadline expires. And if we don't, what the other side will be able to do is have our case dismissed. And as I've noted, we've landed in the territory of possible legal malpractice. And I think just as significant, somebody came to us to get good legal advice and good lawyering, and we let them down, which isn't good no matter how you look at it. Another part of the time limit factors that we've got to take a look at or consider, and again, I'm focusing on New York State practice, is notice of claim. This is even going to be a shorter period of time, and we begin with the observation that lawsuits against municipalities in New York carry with them a notice of claim period. And it's really a two-step process. So the first step is the party who's thinking of bringing a lawsuit and asserting a claim against a municipality, let's say the city of Buffalo, first has to file a notice of claim, and that has to be timely. And if they've timely filed a notice of claim, then they then have to comply with the statute of limitations. And we have a 90-day notice of claim period and a 1-year 90-day statute of limitation. And I'm hoping that winter is broken, but let's take the example here. A person slips on the ice of the steps of Buffalo City Hall and breaks a leg, and retains her hypothetical firm to pursue a claim against the city of Buffalo. So our first filing obligation would be to file a notice of claim. We've got 90 days to do that, to keep the claim alive. And then we would have to bring a lawsuit against the city of Buffalo within 1 year and 90 days after or from the date the claim arose. And when we bring our lawsuit against the City of Buffalo, if we've reached that point, in our lawsuit claim, our complaint, we're going to have to allege that we complied with the statute of, strike that, that we complied with the notice of claim, and even if we filed the lawsuit within 1 year and 90 days and we're okay with the statute of limitations, if we didn't earlier file a timely notice of claim, then we're out of business. As I point out, statute of limitation periods are drop-dead periods. There's a little bit of wiggle room for notice of claim periods for good cause shown, but I never want to be in that position of having to make that argument to a court on good cause shown. Okay, I'm going to stop this video, and we'll have another video up on the next posting.